Hey everyone, Rob Ryder. March 1st, my mother's birthday. Happy birthday, Mom. I did a Google search on deposit deed of trust. Ended up in the definition of mortgage on, I believe it's in Wikipedia. And then from there to escrow. So let's see what they had to say right in Wikipedia for us. A mortgage is a legal document by which the owner, the buyer, transfers to the lender an interest in real estate to secure the repayment of a debt, evidenced by a mortgage note. All right, so I put this in, did not say a promissory note. So I asked for the evidence, just like it says. You want to see the mortgage note. It should say, it needs to say mortgage note. That's what they said it is. Better say mortgage note on it. When the debt is repaid, the mortgage is discharged and satisfaction of mortgage recorded in the register of the recorder of deeds in the county where the mortgage was recorded. Because most people cannot afford to buy real estate with cash, nearly every real estate transaction involves a mortgage. Yeah, okay. So they say. Basically, for less than $20, or maybe not even any money, because a equitable mortgage is nothing more than depositing a title deed in a verbal agreement. We'll make the deposit for you. If they were to say that and you said fine, you think they're depositing the promissory note, well, they're depositing the mortgage or the deed of trust. Um, and as long as it's deposited, that's enough for them to have an equitable mortgage giving them legal title. The party who borrows the money and gives the mortgage, the debtor, is the mortgagor, and the party that pays the money and receives the mortgage is the lender, is the mortgagee. Under early English and U.S. law, the mortgage was treated as a complete transfer of title from the borrower to the lender. The lender was entitled not only to payments of interest and debt, but that rents, profits, in the estate. This meant that, as far as the borrower was concerned, the real estate had no value, that it's dead, until the debt was paid in full, hence the normal English name mortgage, dead pledge. hmm Under early English and U.S. law, the mortgage was treated. So in common law, that's the way it works. But, there's a little bit something different going on. Let's keep going. The mortgage must be executed according to formalities required by the laws of the state where the property is located. It must be described real estate, must be signed by all owners, including non-owners, property, homestead, yada, yada, yada. Sorry about that. There it is again. The mortgage note, in which the borrower promises to repay the debt, sets out the terms of the transaction. So we need to see the mortgage note. We're asking for the mortgage note. The terms of the transaction, the amount of debt, and the mortgage due date, and the rate of interest. Basically everything you need to know is on a thing called a mortgage note. State courts have devised varying theories on legal effects of mortgages. Some treat the mortgage as a conveyance of the title, which can be defeated on payment of the debt. Others regard it as a lien, entitling the borrower to all rights of ownership, as long as the terms of the mortgage are observed. Well, that's just an either or, right? You can defeat it by paying the debt. However, as long as you do what the mortgage says, you have the rights ownership. So if you stop making the payments, right, they can foreclose on you. So in California, deed of trust to a trustee who holds the title for the lender is the preferred security instrument. So in California, a deed of trust to a trustee who holds the title. So the trustee is holding the title in a deed of trust. At common law, if a borrower failed to pay a debt in full at a point of time, the borrower suffered complete lost title, however long and faithful the payments had been made. So you would think in common law, okay, you're going to lose it because you didn't make your payments. However, courts of equity, which were originally ecclesiastic courts, had the authority to decide cases on the basis of moral obligation, fairness, justice, as distinguished from the law courts, which were bound to decide strictly according to the common law. Equity courts softened the harshness of the common law by ruling that the debtor could regain the title even after default, but before it was declared forfeited by paying the debt with the interest and cost. The form of relief was known as equity of redemption. So, a very important word, forfeited, right? As long as whatever it is hasn't been forfeited yet, you can still do equity of redemption. It's as simple as paying off the debt. So, you need to find the mortgage note. And this would be if you lost your house years ago. We're going to find this for everything because everything they do to us is a form of a deed of trust, a form of a mortgage. There's judicial mortgages, conventional mortgages, equitable mortgages. Okay, so nowadays nearly all states have enacted statutes incorporating the equity of redemption. Okay, I see. I'm not going to read all this. Although some debtors or mortgagors are able to avoid foreclosure through the equity of redemption, many are not because redeeming means coming up with the balance of the mortgage plus interest and cost, something that the financially troubled debtor might not be able to accomplish. Mm-hmm. So, what's the mortgage note say? How much money did they lend us? They didn't lend us any money. It could just say, as long as it's on file, there's this agreement that runs with the land. Because as long as you let them deposit your deed of trust, and in this case, we're talking about the title deed being the deed of trust. As long as they get to do that, it's an escrow, and we're going to get to that in just a minute. Um, Failure to redeem results in foreclosure in the borrower's rights in the real estate. Right? So you didn't redeem, therefore they foreclose. Imagine that. Okay, that's more. So a deed of trust is similar to a mortgage with one important exception. The borrower breaches the agreement. If the borrower breaches the agreement to pay off the loan, the foreclosure process is typically much quicker and less complicated than a formal mortgage foreclosure process. While a mortgage involves a relationship between the borrower, homeowner, and the bank or lender, a deed of trust involves homeowner, lender, title insurance company. So, forgetting what the names are, look to see if those players are on there. Is there a title insurance company on your mortgage? Is there a bank on there as the lender? You're on there as the homeowner, right? Then it's a form of a deed of trust. And the title insurance company, as you can see, holds the legal title, basically the equitable mortgage, to the real estate until the loan is paid in full, at which time the company transfers the property title to the homeowner. Okay? They must be the ones holding this mortgage note. Good. Well, it's a good place to start if you're making phone calls. Okay, so mortgage real estate may be sold with the buyer taking either subject to or assuming the mortgage. So this is what happens to your stuff afterwards. Your real estate is mortgaged for less than $20 or just because the damn piece of paper has been deposited. um, and they have us making these payments that are really just a cash flow account um, that are going into an escrow account. And the escrow account, in my opinion, is never touched, but that's what they fractionalize off of. But what you put into the escrow account is yours. It's just being held there until the mortgage is paid, which is, less than $20. Or just asking for the damn piece of paper back. And lenders regularly assign mortgages to other investors. Okay, well, that's all good. Let's go down here. Escrow. So now we're talking about escrow. An escrow also refers to a writing deposited with someone until the performance of an act or the occurrence of an event specified in the writing. So it can be called an escrow. Guess what? A mortgage note sounds like it can be called an escrow. Refers to a writing deposited with someone. So the mortgage note has been deposited as an escrow until something happens. The directions given to the person who accepts delivery of the documents are called the escrow agreement and are binding between the person who promises and the person to whom the promise is made. So now we get a thing called an escrow agreement. These are things that we'd be asking to see in a foreclosure. I want to see these things with these names on them. A writing is held in escrow by third person until the purpose of the underlying agreement is accomplished. So the writing is held in escrow, and we have these escrow accounts, right, that go to our paperwork. Look at it, it's got an escrow account on there. When the condition specified in the escrow agreement is performed, the individual holding the writing gives it over to the party entitled to receive it. This is known as the second delivery. Complete the condition specified, and then they're going to turn it over to the party entitled to receive it. Any written document that is executed in accordance with the requisite legal formalities may properly be deposited in escrow. Documents that can be put in escrow include a deed, a mortgage, a promise to pay money, a bond, a check, a license, a patent, a contract for sale of real property. Lots of things look like they can go into escrow, because escrow is really just giving it to somebody to hold. The title deed. We deposited the title deed with somebody, it went into escrow. The term escrow initially applied solely to the deposit of a formal instrument or document. However, it is properly used to describe a deposit of money. Well, imagine that. The escrow agreement is a contract. The parties to such an agreement determine when the agreement should be released prior to making the deposit. After the escrow agreement has been entered, the terms of holding and releasing the document or money cannot be altered in the absence of an agreement by all the parties. So the escrow agreement is a contract. We're looking for the escrow agreement. The parties to such an agreement determine the agreement should be released when the agreement should be released prior to making the deposit. After the escrow agreement has been entered, the terms of holding and releasing the document or money cannot be altered. So releasing the document or the money, the document or all that hard-earned money you put into this escrow account that's sitting there, all these payments you've made are sitting in the escrow account. A depositary is not a member to the escrow agreement, but rather a custodian of the deposit, who has no right to alter the terms of the agreement or prevent the parties from altering them if they so agree. The only agreement that the depository must make is to hold the deposit subject to the terms and conditions of the agreement. Ask them what the terms, we need to ask them what the subject to the terms and conditions of the agreement are. Ordinarily, the depositor has no involvement in the underlying agreement. However, an interested party may, in a few states, be selected to be a depository if all parties are in agreement. In all cases, a depository is bound by the duty to act according to the trust placed in him or her. That's wonderful to know. Full faith and credit. If the depository makes a delivery to the wrong person or at the wrong time, he or she is liable to the depositor. The document or the money is only in escrow upon actual delivery to the depository. Ordinarily, courts are strict in their requirement that terms of the agreement be completely performed before the deposit is released. Okay? So whatever the agreement is, we just need to perform it. A reasonable amount of time must generally be allotted for performance. Parties may, however, make agreement that the time is of the essence, and in such a case, a delay beyond the period specified in the agreement makes the individual who is obligated to act forfeit all his rights in the property in escrow. So the document or the money is only in escrow upon actual delivery to the depository. So if it's in the escrow, if it's in there, it's in there. It's already been delivered to them, and it's only being held until we perform the mortgage note. So let's go back and look at some words here. Mortgage note. In California, the deed of trust is held by the trustee. Okay, he's got the original. He's got the title deed that we need to get our hands on if you're in California. And you're going to ask him how to do that. You're going to ask him, as we go back down, what the payoff is, what the loan payoff is in money, not in Federal Reserve notes, for the mortgage. As where's that word? Mortgage agreement? Was that what it was? No, mortgage note. That's what it is. A mortgage note. So, okay. Well, listen, just more evidence that's pointing to all we need to be doing instead of all this arguing with them is go to the title company and tell them what's the payoff for the mortgage note. What's the terms and conditions for the mortgage note to this escrow here? You need to have a copy. They have to have a copy because they're the ones who have to follow the agreement. So they better have a copy and they better send you one. Okay, that's it for now. One step closer. See ya.